Good day, everyone, especially to you, Dr. Jeah. My name is Jeah Rojo, and today we're going to talk about the Chapter 7, which is the laws regulating transportation establishments. And before we proceed, I will be providing to you the topic outline and objectives. So, first, the introduction for the importance of transportation laws in tourism and public safety. Next is the common carrier laws with a definition, obligations, liabilities, and enforcement of the legal responsibilities, and also the regulation of transportation for air, sea, and land, and also the key transportation laws such as the Seatbelt Law, Animal Welfare Act, and importation of vehicles, public service and traffic laws, local government regulations on tricycles and pedicabs, and lastly, some application of the law or like case studies and legal interpretations on it. So for the objectives for this topic, first is to explain the legal framework governing transportation in the Philippines. Next is differentiate between common carriers and private carriers. Next is understanding the obligations and liabilities of transportation establishments. Identify the roles of regulatory agencies in different transportation sectors. And next is analyze the application of laws through case studies and discuss the implications of traffic laws, safety regulations, and public service laws on transport operations. So, the Philippines has become one of the promising tourist destinations due to the extraordinary hospitality of the Filipinos and the diversity of tourist attractions in the country. However, one challenging aspect of promoting inbound tourism in the Philippines is the security and safety issue. On one hand, some of the best transportation and travel professionals are Filipinos, like seafarers, pilots, drivers, flight attendants, cruise cabin crew, aircraft mechanics, and etc. So, on this chapter, we will deal with the different laws affecting the transportation sector as they are integral in the study of tourism. So, first is the law on common carriers. It is the primary law that governs common carriers, and that is the Civil Code of the Philippines, as clearly implied from Article 1766 thereof, which states that in all matters not regulated by this code, the rights and obligations of common carriers shall be governed by the Code of Commerce and special laws. So the law. It is in Article 1732 that common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods or both by land, water, or air for compensation, offering their services to the public. So, common carrier. What is a common carrier? So, it is defined as one holding itself out to the public as engaged in the transportation of freight or passenger for hire. It is one who is in the business of transporting goods or persons for hire as a public utility. While on the other hand is a private carrier, which is not in the business of transporting public employment, but hires out to deliver goods, not passengers in particular cases. So both the Civil Code and Code of Commerce give clear-cut divisions between contracts of carriage of cargo and contracts of carriage of passengers because the rights and defenses in each kind of contracts are different from the other. And the nature of contract of carriage. So, a contract to transport passengers is quite different in kind and degree from any other contractual relation. And this is because of the relation which an air carrier sustains with the public. So, it invites people to avail the comforts and advantages it offers. So, the contract of carriage therefore generates a relation attended with a public duty. Neglect or malfeasance of the carrier's employees naturally could give ground for an action for damages. So, I will be providing to you the discussion of the law, and we're going to go on deeper with regards to the law for transporting or for transportations. So for this one, as soon as the passenger puts his foot on the platform, the obligation of extraordinary diligence of the common carrier begins. So the relation of carrier and passenger does not cease at the moment the passenger alights from the carrier's vehicle at the place selected by the carrier at the point of destination, but continues until the passenger has had a reasonable time or reasonable opportunity to leave the carrier's premises. And a certificate of public convenience is not a requirement in order for a common carrier to incur liability. Such liability arises from the moment a person or firm acts as a common carrier, without regard to whether or not such carrier has been granted a certificate of public convenience or has complied with the requirements of the applicable implementing regulations. So in a contract of carriage of passengers, it is the obligation of the common carrier to bring the passengers safely to the point of destination. If injured or death occurs, the presumption of negligence automatically arises, and the common carrier can be held liable if he fails to prove extraordinary diligence for the duration of the carriage. So next is we have the enforcement of liability of common carriers. So the liability of common carriers can be enforced in the following cause of action. First is in case of death or injury caused to passengers. So for this one, the victim may file a case of breach of contract of carriage or culpa contractual against the owner of the common carrier if it happens. And second, in case of death or injury caused to a stranger or pedestrian. So for this one, the victim may file a criminal complaint against the driver of the common carrier for reckless imprudence resulting in homicide and damage to property. And the victim may also file a civil suit against the common carrier and its drivers on the ground of culpa acquiliana or quasi-delict. So next is we do have the damages recoverable from common carriers. In action based on culpa contractual or culpa acquiliana, the damages that are recoverable are as follows. First is the actual damages, compensatory damages, moral damages, exemplary damages, death indemnity, and attorney's fees. So, nominal damages may be awarded in case moral or exemplary damages may not be awarded. So first, we have the actual damages. It consists in expenses for medicine, hospitalization, and etc. Next is we do have the unrealized profits. These are recoverable as compensatory damages, which shall be fixed by determining the net yearly income of the injured or passenger and multiplying the same by the number of years that he was expected to live or lead a gainful existence as determined by morality tables of life insurance companies of the Philippines. Next is we do have the moral damages. So this may be awarded when the mishap resulted in the death of a passenger, or when the heirs of the deceased suffered from mental anguish, or when the carrier was guilty of fraud or bad faith, even if death did not result. So the big amount of damages will be awarded in view of the importance of the person or the passenger. Next is we do have the exemplary damages, in which it is also called as corrective damages, which are awarded by way of example or correction of the public good, or when the common carrier acted in wanton, reckless, and oppressive manner. So while the immediate beneficiaries of the standard of extraordinary diligence are of course the passengers and owners of cargo carried by a common carrier, they are not the only persons that the law seeks to benefit. And the Article 2231 of the Civil Code explicitly authorizes the imposition of exemplary damages in cases of quasi-delicts if the defendant acted with gross negligence. Next is we do have the award for death indemnity. It is in accordance with the current rulings of the court. And next, we also have the award for attorney's fees, and it may be recovered when exemplary damages are awarded. So, under Article 2008 of the Civil Code, attorney's fees may be recovered when exemplary damages are awarded. So, in the case of Metro Manila Transit Corporation versus Court of Appeals, it was held that an award of 50,000 pesos as an attorney's fees is reasonable. And also, we do have the in-case moral damages. It cannot be awarded without proof of the carrier's bad faith. Ill will, malice, or wanton conduct, nominal damages may be allowed under these circumstances. And nominal damages may be awarded as provided under Articles 221 and 2222 of the Civil Code of the Philippines for the purpose of indemnifying the victim for any loss suffered by him. Nominal damages are recoverable if no actual, substantial, or specific damages were shown to have resulted from the breach. So the amount of such damages is addressed to the discretion of the court, taking into account the relevant circumstances. So next is we do have the nature of airline, bus, and shipping tickets. So the best evidence of a contract of carriage is the passenger ticket or the passage ticket. Under our jurisprudence, an airline, bus, or shipping ticket is a contract of adhesion, considering that all the provisions thereof are prepared and drafted only by the carrier, and the only participation left of the party is to affix a signature, and in such situation, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the same in the case of the carrier. So, application of the law. So, I'll be providing to you like a circumstance or a case study for this one. So, Sweet Line Incorporated is a shipping company transporting inter-island passengers and cargoes. A stipulation in its passenger ticket states that it is hereby agreed and understood that any and all actions arising out of the conditions and provisions of this ticket, irrespective of where it is issued, shall be filed in the competent courts in the city of Cebu. So the question is the stipulation valid? So for legal opinion, the answer would be no. Such stipulation is void. Such stipulation subverts the public policy on transfer of venue of proceedings of this nature, since the same will prejudice rights and interests of immutable passengers or innumerable passengers in different parts of the country who will have to file suits against Sweet Line Incorporated only in the city of Cebu. The protection by the courts of the disadvantaged is expressly enjoined by Article 24 of the Civil Code, which states that in all contractual, property, or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, and other handicap, the courts must be vigilant for his protection. So next is the regulation of the transportation business. So the Department of Transportation and Communications, or DOTC, is the primary policy, planning, programming, regulating, and administrative entity of the executive branch of government in the promotion, development, and regulation of the dependable and coordinated networks of transportation and communication system, as well as in the fast, safe, efficient, and reliable postal transportation and communication services. So it has the power of authority and technical expertise to determine whether or not a specific transportation or communications project is necessary, viable, and beneficial to the people. So next is the regulation of air transportation business under the Legislative Act number 3909, passed by the Philippine Legislature on November 20, 1931, created an office under the Department of Commerce and Communications to handle aviation matters, particularly the enforcement of rules and regulations governing commercial aviation as well as private flying. It was amended by the Act of 3996 to include licensing of airmen and aircraft, inspection of aircraft concerning air traffic rules, schedules and rates, and enforcement of aviation laws. On June 20, 1952, the Republic Act No. 776, otherwise known as the Civil Aeronautics Act of the Philippines, was enacted, which defined the powers and duties of the Civil Aeronautics Board, personnel, and the regulations of civil aviation. On April 4, 1987, under the Executive Order No. 125, was enacted, creating the Air Transportation Office. Next is the Civil Aeronautics Board, or also called as CAB. So it is the one who regulates the economic aspect of air transportation and has general supervision and regulation and jurisdiction and control over air carriers as well as their property rights, equipment, facilities, and franchise. So it has the power to fix and determine reasonable rates, charges, or fares which an air carrier may demand, collect, or receive for any service in connection with air commerce. So also we do have the Air Transportation Office, which is called ATO or ATO, and it is primarily charged with the technical and operational phase of civil aviation matters. So next, we do have the registration of aircraft. So only aircraft owned by or leased to citizen or citizens of the Philippines and which are not registered under the laws of any foreign country may be eligible for registration. So the certificate of registration is conclusive evidence of ownership, except in a proceeding where such ownership is an issue or when the aircraft is only under lease. So next is the regulation of the shipping industry. The Maritime Industry Authority, or also called as MARINA, was created on June 1, 1974, with the issuance of Presidential Decree Number 474 to integrate the development, promotion, and regulation of the maritime industry in the country. It was originally placed under the office of the President, and with the creation of the Ministry, or now called as Department, of Transportation and Communications, by virtue of Executive Order Number 546, the Marina was attached to the DOTC for policy and program coordination on July 23, 1979. So, the authority to operate: no franchise, certificate, or any other form of authorization awarded by Marina for the carriage of cargo or passenger, or both in the domestic trade, shall be granted except to domestic ship owners or operators. The term domestic ship owner or operator means a citizen of the Philippines or a commercial partnership wholly owned by Filipinos, or a corporation at least 60% of the capital of which is owned by Filipinos, which is duly authorized by the Maritime Industry Authority to engage in the business of domestic shipping. So the regulations of the land transportation. The concept of land transportation system in the Philippines started when our ancestors invented means of locomotion. The early means of transportation used were animals and moving people and goods from place to place. Although the means of land transportation during the early days were not as sophisticated as the modern vehicles of today, and the roads were not as well constructed, the early Filipinos also observed some forms of laws to govern their mobility. These laws were as informal and simple as specifying which animal could be used for certain purposes. However, the existence of these rules show that our ancestors had already felt the need to regulate the transportation system. So today, it is the Land Transportation Office, or LTO, and the Land Transportation Franchising and Regulatory Board, or LTFRB, which are the agencies involved in the regulation of the Land Transportation Authority or industry. So first, the Land Transportation Office. So the LTO is a proper agency which controls the registration and operation of motor vehicles and the licensing of owners, dealers, conductors, and drivers, and similar matters. So under the Clean Air Act of 1999, vehicles must pass the emission testing requirements to be administered by the Department of Transportation and Communications as a prerequisite for registration. Next, we also do have the LTFRB, or also known as the Land Transportation, Franchising, and Regulatory Board. So it is a government agency in the Philippines responsible for regulating public land transportation services. It grants franchises, ensures compliance with laws, sets fare rates, and oversees the safety and efficiency of public transportation system. Next, we have is the seatbelt law, which was enacted to secure and safeguard its citizenry, particularly the passengers and drivers of private and public motor vehicles, from the ruinous and extremely injurious effects of vehicular accidents. So, in order to secure the safety of the passengers and drivers at all times, the mandatory enforcement of the use of seatbelt devices by the drivers and front seat passengers of private and public motor vehicles shall be enforced. Next is we have the Law on Transportation of Animals. So by virtue of the Republic Act 8485, also known as the Animal Welfare Act of 1998, it shall be the duty of any operator of any land, air, or water public utility transporting pets, wildlife, and all other animals to provide in all cases adequate, clean, and sanitary facilities for the safe conveyance and delivery thereof to their consignee and at the place on confinement. So for these animals that will be transported shall be provided sufficient food and water while in transit for more than 12 hours or whenever necessary. No public utility shall transport any such animal without a written permit from the Director of the Bureau of Animal Industry or his or her authorized representative. Any form of cruelty shall be penalized even if the transported has obtained a permit from the Bureau of Animal Industry. Cruelty in transporting includes overcrowding, placing animals in the trunks or under the food trunks of the vehicles. Next is we do have the law on importation of vehicles. So there are relevant laws on the importation of vehicles which may be useful for the transportation business, namely the Republic Act of 7227, which allows the free flow of goods and capital within the Subic Bay, Freeport in Subic, and province of Zambales in order to attract investors to invest their capital in a business climate with the least government intervention. So President Arroyo's Executive Order 156 prohibits the importation of used motor vehicles into the country. We do have another law for the public service laws. So the public service includes every person who may own, operate, manage, or control in the Philippines for hire or compensation, with general or limited clientele, whether permanent, occasional, or accidental, and done for general business purposes, any common carrier, railroad or street railway, traction railway, subway, motor vehicle, steamboat or steamship line, ferries, and watercraft or shipyard. Unless otherwise exempt, no public service shall operate without having been issued a certificate of public convenience or a certificate of public convenience and necessity. Next also is we do have the traffic laws. Under the Republic Act of number 4136, which is enacted on June 20, 1964, is a compilation of laws relative to traffic rules and regulations. Also, we do have the restriction as to speed. In the Philippines, speed limits for various types of transportation are regulated to ensure safety. For passenger vehicles, the speed limit is generally 60 km per hour on city roads and up to 100 km per hour on expressways. Public utility vehicles or PUVs must adhere to specific limits set by the Land Transportation Office, and speeding violations are subject to fines and penalties aiming to reduce accidents and promote road safety. So, restrictions on overtaking and passing. So, the driver of a vehicle shall not drive to the left side of the center line of a highway in overtaking or passing another vehicle proceeding in the same direction, unless such left side is clearly visible and is free of oncoming traffic for a sufficient distance ahead to permit such overtaking or passing to be made in safety. And next, we also do have the parking prohibition. No driver shall park a vehicle or permit it to stand, whether attended or unattended, upon a highway in any of the following places. A. Within an intersection. Next is also on a crosswalk. Also within 6 meters of the intersection of curb lines. Within 4 meters of the driveway entrance to and fire station. Within 4 meters of fire hydrant. In front of a private driveway. On the roadway side of any vehicle stopped or parked at the curb or edge of the highway, and at any place where official signs have been erected prohibiting parking. So, for driving or parking on a sidewalk, no person shall drive or park a motor vehicle upon a long or any sidewalk, path, or alley not intended for vehicular traffic or parking. So, for driving and substance intake, no person shall drive a motor vehicle while under the influence of liquor or narcotic drug. An obstruction of traffic, no person shall drive his motor vehicle in such a manner as to obstruct or impede the passage of any vehicle, nor while discharging or taking on passengers or loading or unloading freight, obstruct the free passage of other vehicles on the highway. So for our conclusion, laws regulating transportation establishments are very important and crucial for ensuring passenger safety, fair business practices, and efficient transportation services. These laws establish standards for vehicle maintenance, driver qualifications, and operational safety, reducing the risk of accidents and protecting consumers. They also regulate pricing, liability, and accessibility, ensuring that transportation providers operate fairly and do not engage in overpricing or discrimination. Additionally, these laws provide a legal framework for resolving disputes, enforcing penalties for violations, and promoting sustainable transportation development. And also, transportation laws enhance public trust, economic stability, and the smooth movement of people and goods within a country. So I hope you have learned something. Thank you so much for listening and have a great day.